Hello and welcome everyone to our webinar, Navigating Commercial Leases, a guide for small business owners. We are excited that you have joined us tonight. This webinar is brought to you by the Boston Local Development Corporation, BLDC, and the Transactional Law Clinics of Harvard Law School, TLC. My name is Simon Huang, and I am the Finance Assistant at the BLDC. Now I'll hand it over to Gisela Soriano, who will introduce herself and speak more about BLDC.
Hello, everyone. It is a pleasure to be here with you tonight. I'd like to start by giving you an overview of the loan program. As my colleague Simon mentioned, my name is Gisela Soriano, and I am the manager of the BLDC. BLDC offers loans to businesses physically located in the city of Boston. BLDC is an independent 501c3 that is managed by City of Boston employees, Simon and me, and governed by a board of trustees, the folks that you see here on the right, who have years of experience in the finance, economic, and legal industries. The mission of the BLDC is to lend to businesses that are going to retain and/or create jobs in the local community. Could I have the next slide, please? Our loan amounts range from 40,000 to 150,000 for most industries and up to 250,000 for those businesses in the manufacturing industry. We have a formal loan application that allows us to assess the business and the business financials, the credit report, usage of the loan, and their ability to repay the loan. The loan funds can be used for working capital, to purchase equipment or inventory, pay off high interest debt, and other business needs. And the processing time between the submission of the loan application and the approval really depends on the completeness of the application. And could I have the next slide, please? Just to give you here on this next slide some more information about the loan process. In terms of the loan application, Simon and I are available to help the applicant with guidance throughout the process, any questions that they may have at the beginning, middle, or the end of the process. Could I have the next slide, please? So this is a map that shows the neighborhoods that are in Boston. We are not able to lend to businesses located outside of the city of Boston. We do partner with other organizations that do lend to businesses that are in Boston and outside of the city of Boston, and we'd be happy to refer you to them for more information. Could I have the next slide, please? So here are two businesses that have received loans from BLDC. On the left here, we have Lazy Bear Creamery that is located in Dorchester. And here on the right, we have Marvelous Cuts that's located in the financial district. And the next slide has a list of the organizations that we partner with. These organizations provide consulting services and resources to businesses like yours, and we work closely with them. Some of these organizations are also nonprofit organizations that provide funding. Next slide, please. Here's our contact information. If you are a Boston business owner in need of funding or looking to open a new business in Boston, we would welcome the opportunity to help you. The first step is to complete our intake form that's located on our website. Once we receive it, we will contact you to schedule a meeting. During the presentation, I will be typing in the chat that is the bottom of your screen, more information on BLDC, as well as our partnering presenter, which is the Transactional Law Clinics as well, so that you can get more information and look at the websites for each organization. Now I'll pass the presentation to Simon.
Thank you, Gisela, for giving that quick overview about the BLDC. If you have any questions during our presentation, please type them at the bottom of your screen using the Q&A feature. Here's what it looks like. At the end of the presentation, I will read out loud the questions. And after the questions and the Q&A have been answered, we'll also open up the floor for our attendees to ask questions verbally. You may ask questions using the raise hand feature at the bottom of your screen to ask questions. And now it is my pleasure to introduce the team at the TLC. We have several amazing folks with us here tonight. I will pass the presentation to Darian Hubert, student attorney at TLC.
Yeah, thanks so much, Simon. And thank you to both yourself and Gisela and BLDC as general for having us here today. Now give me a moment to share my screen. All right. So we're really excited to be here today with all of you and to give this presentation. And before we dive into the meat and potatoes of today's presentation, we would just like to spend a few minutes first introducing the Transactional Law Clinics, also known as TLC, our Harvard Law School, as well as ourselves. And the transactional law clinics at Harvard Law School offer low cost or free legal services to small business owners, entrepreneurs, nonprofit organizations, community associations, musicians, and artists in several different areas that include business formation, contracts, commercial leasing, nonprofit formation and tax exemption, entertainment and intellectual property, as well as permitting and licensing all throughout the Massachusetts area. And as Simon mentioned, at TLC, law students here are supervised by licensed attorneys who are experienced practitioners, and they also serve as our mentors throughout the semester. The TLC's legal services do not cover or include anything related to litigation or dispute resolution. And just by way of introduction, like I mentioned, my name is Darian. I am a third-year student at Harvard Law School, and I am working as a student advocate this semester at TLC. And after law school, I plan to do transactional work for a law firm here in Boston. And Lawrence, if you'd like to introduce yourself as well.
Absolutely. Hello, everyone. My name is Lawrence. I'm also, like Darian, a third-year law student at Harvard Law School. Super excited to see you all tonight. I'm a part of the Transactional Law Clinic. After law school, I'll be working at a big law firm doing contract work in New York City.
And we're also joined here today by Aaron Cho and Patricia Alejandro, who are clinical instructors and attorneys at TLC. And before we go any further, just a quick disclaimer for TLC is that, like I already mentioned, myself and Lawrence are students here at the Transactional Law Clinic, and we're not licensed attorneys. We work underneath instructors like Aaron and Patricia, who are licensed attorneys. And this workshop presentation is intended to be informative and provide general guidance on commercial leases. Nothing we say in this presentation or the Q&A should be considered legal advice. And with that out of the way, I'd like to turn it back over to Lawrence, who will get us started.
Sweet. Thank you, Darian. Super excited. Let's just jump in a little bit with a brief icebreaker. As Simon alluded to earlier, you can have access to communicate with us in the chat. We just want you to take a look at the image on your screen and tell us what you see in the chat. We'll just look at some of your answers. We want you guys participating with us tonight, so if you can just drop an answer in. I'll wait maybe 5 more seconds or so to see what pops up here. Okay. So someone says a fancy woman facing away. Someone says an eagle. Okay, I have not seen that one yet, but okay, I love to see it. Someone says artwork. Someone says an old woman. Well, the purpose of this image, and really what you should see is either the young woman looking over her shoulder, or if you look towards her chin and zoom out just a little bit, you should also see a more elderly woman, just as beautiful, I'm sure. But the point of this illustration is just to show you that looking at the same image, you might see different things depending on the perspective that you're looking at the image from. And that's a lot like what we're going to be talking about tonight, that the same provision in a lease may be viewed differently based on your perspective. Now, let's take a look at the next image on your screen. Anyone seen this one before? What is this? If you can drop it in the chat. What is this an image of? I know this is a little bit of a throwback. Awesome. Yeah, where's Waldo? And this one is actually pretty easy. I love that, Kate. Thank you. Waldo is actually really in the middle of this one. So this is easy to identify. But how about this real challenge? On the next screen, you'll see this image. Can you find Waldo now? I'm going to let 10 seconds. And if you can't find it, we'll move on. 5, 4, 3, 2, 1. All right, so this one is a bit of a trick because I still have not been able to find Waldo in this image, neither Darian or our entire team. The point of this illustration is commercial leases can be quite complex, and oftentimes the provisions that we might mention or that you might be looking for are hidden throughout like dense language. And it's important that you really comb through your lease, look at every provision, and sometimes, something may not even be there. So it's important that you understand or seek consultation when talking about a commercial lease. So with that, we're going to just give a brief roadmap, or discuss what is a commercial lease, and then give a brief roadmap for tonight's session. A commercial lease is a contract between a property owner and a business owner where there's an exchange for a right to use a premise for what we call consideration. That's your monetary payment or rent. Tonight, we're going to discuss this in a few different parts. First, we're going to go through key lease terms and tips for negotiating favorable lease terms. We're going to do a checklist for you to consider before you sign a lease. Then we're going to talk about some defaults and remedies available to landlord and tenants if someone violates their lease. And then we'll end with a Q&A session. So if you do have a question throughout our presentation, drop it in the chat. Simon and the rest of the team will be monitoring it and preparing answers for the end. And then we'll get to them, the questions at the end of the session. With that, I'm going to turn it back over to Darren. That's going to kick us off with some key lease terms.
Thanks, Lawrence. I know that Where's Waldo second picture is definitely going to be haunting me in my sleep. But like Lawrence mentioned, just to kick things off, we'd like to walk through 4 different categories of key lease terms, explain what each of these lease terms encompasses, and then how you can negotiate and suggest provisions with a prospective landlord to potentially heighten your protections as a tenant. And then finally, for this section, we'll be sharing some general negotiation tips to keep in mind. So first things first, we'll really be discussing the foundational structure of a lease, thinking who's involved, what's being rented, for how long, and potentially even how to get out of your lease if you need to. So first things first, there are the parties to the lease. And in a typical commercial lease, that will be the landlord, also known as the lessor, and the tenant. And that will be you, likely, also known as the lessee. But, for the sake of this presentation, we'll be referring to it simply as the landlord and the tenant. And one tip here when reviewing the parties' lease term provision is to make sure that only the parties listed in this section will have the rights and obligations that are established by the lease. Because of this, it's really important that the party name is on behalf of your business and not yourself. For example, if it was instead in your own name, you personally could be on the hook for the obligations and therefore personally liable for rather than your business. In general, it's really important to make sure to keep your business separate from yourself in all aspects. For example, you should be entering into contracts like commercial leases as your business. You should be taking out loans in your business's name, and you should be making sure to keep separate bank accounts and finances for your business separate from your personal. And then the second lease term we'll be discussing today is the premises. And so the premises term in your commercial lease will define the space that is being leased, the actual physical space. So typically this will include things like the location address, the building, and even the square footage. A couple tips to keep in mind here when reviewing that premises term in your lease is to ensure that the square footage in the lease matches exactly the information you've been given or have measured yourself. Make sure that what you've been told is matching up and accurate with what's written down on that lease. And some leases will include a section in the premises portion titled condition. And in this, they might say something along the lines that the tenant shall accept the premises as is in their condition. And if this language is included in your lease, be sure to inspect the property before you sign and make sure that you are satisfied with its condition. And if there are some things that maybe you're not satisfied with, and there's changes that you would potentially want to be made, try to talk to your landlord about that and try to maybe get some changes made to that or have that added in and explicitly stated in the lease. And if you look here on your right, I've suggested one provision that you could try to negotiate and add into your lease. And this provision here on the right is essentially just saying that the premise will be delivered to you as the tenant in good, clean condition. This will just make sure that, when you do take over that commercial lease, there's nothing, major you need to repair. It's not going to be a mess. You can really hit the ground running with your business. And just as a note for the remainder of this presentation, these slides will be available on BLDC's website afterwards. So for example, this provision here, you don't gotta, scribble it down frantically. It will be available to you afterwards and you'll feel free to go back to it. So next we'll be talking about the lease term, and this provision of your commercial lease will describe how long you're renting the property for. And this provision might specifically refer to a few different dates, and it's really important to understand what each one of these stands for to fully understand what your lease term is. So the first date you might see is called the effective date, and this will be the date that you sign the lease. And the second date you might see is the occupancy date, and this is the date that you can actually move into the physical space. In general, when reviewing the lease term provision on your lease, make sure you understand what the dates are and what they're referring to, because sometimes the language might be different, even from what we're discussing here today. And in general, the length of commercial lease terms really varies, and the right length for your term will be really a specific question for your business and your business's needs. In general, commercial lease terms typically range from about 3 to 10 years, and 5 years is one of the most common lease terms. A couple of tips to keep in mind when you're reviewing that lease term provision is to really make sure you're confirming the length of that initial lease term. There might be renewal options, and we'll be getting to that next, but make sure you understand how long the lease term is for that initial portion. And consider adding in a provision like you see here on this slide to the right that will give you protection should the landlord delay for any reason having the space available to you by the occupancy date. So for example, say the lease says you're ready to move in October 1st, that's your occupancy date, and then the landlord says to you, hey, there's some sort of delay. This provision will give you just a little bit of added protection, and it could even, as written, create an obligation for the landlord to adjust your rent for the first month should they fail to deliver it by the occupancy date. So this might be something you could try to negotiate with your landlord to have language like this added in if it's not in there already. And then thinking about the renewal of lease term provision of your commercial lease, this will basically be laying out your options to customize should you like to renew your lease after the initial term. And one tip here to consider when you're thinking about your lease term and your renewal lease term options is just to remember that there can be different pros and cons to a short-term versus long-term lease. So really think of how long you want your lease and what best fits your business needs. So for example, if you're a newer business, it might be more beneficial to you to have a shorter lease term with more lease renewal options while you get your business off the ground, even if this might mean paying higher rent to start. And then on the flip side, if you're confident in your business and the location, or if your business involves significant equipment or modifications to the space, you might appreciate the stability of a longer initial lease term with fewer options to renew. And then thinking about termination, so thinking about potential ways that the lease could end. The termination provision of your lease will lay out your options to terminate the lease before its actual end term, should you wish to or need to for some reason. And just keep in mind for the termination provision that you might be on the hook for a certain amount of rent or fee should you terminate your lease early. And you might be able to try to negotiate this with your landlord, but definitely make sure you understand your obligations should you have to terminate early, what exactly you're going to be on the hook for. And so you might try to negotiate this provision to encompass any possible worries you have about your business. For example, if you're worried about your business not being able to sustain sales over a long period of time, consider trying to negotiate with your landlord to add in a termination provision for if your sales fall below a certain level. And tenant rights to terminate a lease often might include providing written notice and sometimes paying an additional fee. be sure to just review this termination lease provision very closely so you understand fully what your obligations are if that happens. And next, looking at the notice provision of your lease, of your commercial lease, this will lay out the ways in which you and your landlord are formally obligated to contact each other and for what. So when you're reviewing the notice provision of your lease, consider and make sure you understand first and foremost what types of communication you're required to provide notice for between your landlord. This could be things maybe like different requests, different approvals you need, perhaps different demands. And then make sure you understand as well as when you need to give your landlord notice by. So there will likely be a different notice requirement for different occurrences. And for example, written notice to terminate a lease might need to be done much further in advance than written notice if something has been damaged at the property. So really make sure you understand what those timeframes are, and your notice provision should hopefully lay that out. And finally, consider and make sure you understand how you and your landlord will communicate with each other. Best practice absolutely will to be make sure it's some sort of text that you could save. So think about email, mail, maybe even fax. And if, for example, you are communicating with your landlord by email and that's what the notice provision of your commercial lease says, make sure you're including a business email that you're most likely to check rather frequently. So now that we've gone through the kind of foundational structure of a lease and some of the bigger picture lease provisions, we'll be talking about financial responsibilities and costs. So, who's responsible for paying what and how are you sharing these costs? So first things first is the rent provision, and this will describe how much you as the tenant will be paying to the landlord and how often. And, similar to residential leases, the rent will typically be paid monthly to your landlord. However, keep in mind that the rent won't always cover things like utilities and other payments, and those might be separate. So really make sure when you read this rent term provision that you're understanding exactly what the base rent covers. So when reviewing the rent provision, specificity is really going to be your best friend for this provision. Make sure the wording is as specific as possible. This provision should be laying out how much you're paying, when you will be paying, and perhaps even how you're paying the rent to the landlord. If there's any language that seems vague, be sure to clarify this with your landlord before signing. And so, for example, one thing that often comes up is real estate taxes are often the responsibility of the tenant, but they're not included in rent. So make sure to understand what your other financial obligations might include when you're considering, your overall budget and what you would be able to afford for your base rent payment. And then on top of things like additional payments like utilities and real estate taxes, when you're considering how much rent you and your business can pay, also consider if there's any rent adjustment provisions. So rent adjustment provisions will describe in what circumstances your rent will increase. And some reasons might include, an increase in real estate taxes, an increase in operating expenses. And if you look at this provision here on the right, this is a suggested provision you could try to negotiate with your landlord to get added in that is essentially going to ask your landlord to provide evidence or justification of any increase in your rent that's resulting in an increase in taxes or increase in operating expenses. So finally, and moving on to another financial responsibility is the utilities. So the utilities provision will be laying out, as you might guess, who's paying the utilities between the tenant and the landlord. And a couple tips here to keep in mind when you're reviewing this provision is to ensure, again, similar to the rent provision, that this language is very specific. Make sure that it's laying out who will be paying what, when they will be paying, and how will they be paying. Make sure that the lease states who's responsible also for repairs to provided utilities for things like the water heater, plumbing, electricity, and other meters. And if you're on the hook to pay for certain utilities, but not for others, so say, for example, you are responsible and on the hook for paying electric, but not for heat, make sure they're separately metered. You don't want to be on the hook paying for someone else's utilities. And in addition, if you're required to pay a reasonable proportion or reasonable allocation of utilities, make sure to discuss this with your landlord so you understand exactly what this means and what your obligations are. And finally, wrapping up the financial responsibilities section, we'll be discussing security deposit and common areas. So the security deposit is money held and returned by the landlord back to you if the property meets certain conditions at the end of your lease. Typically, this will be returned to you at the end of your lease as long as you comply with the lease and there's no damage to the property that you've caused. And if there was significant damage to the property that you've caused, the landlord could take money out of the security deposit and use it to fix the damage. And when you're reviewing your security deposit lease provision before you send the lease, make sure it's including some sort of time frame for how you're going to get that security deposit back at the end of your lease. And finally, the common areas provision, which, in addition to rent and utilities, will be laying out those extra common spaces you might be paying for access to. And this provision will be likely laying out and identifying what those spaces are. And, just keep in mind, you'll be sharing them with others. Some examples of common areas are things like lobbies, parking lots, conference rooms, restrooms, and hallways. And keep in mind also that the landlord will likely have unlimited access to these areas as well. And one tip to keep in mind when reviewing the common areas provision is to really think about what your business is going to need. For example, will you need parking for employees or customers? Will you be needing access to restrooms? Make sure you're thinking about what's crucial to your business. And now, before I hand it back over to Lawrence, who will be discussing some more categories of key lease provisions, I just want to remind you that should you and your landlord agree to any changes after you sign the lease, say, for example, a change in who pays the utilities or what common areas you can access, remember to get these changes in writing and amend your lease as well. So without further ado, I'll hand it back over to Lawrence, who will keep going through these key lease provisions.
Thank you, Darian. Now let's pick up where Darian left off. Now we've gotten the money out of the way, and you have now occupied the property or you're about to occupy the property. What are some things that you need to consider as you are going to take hold of the premise and are going to be operating a business out of it? The first thing is the use of the premise, which is usually outlined within the commercial lease agreement. There are a few things that you need to consider and find out where it may have stipulated this in the commercial lease. The first thing is the acceptable use. The lease would usually enumerate or spell out exactly what you're able to use the premise for. And so it would be things like, are you going to operate a daycare or a restaurant or a retail or a service space? Whatever your intended use of the premise is, it should be spelled out in the commercial lease so there's not a conflict between you and the landlord. And the commercial lease will also let you know some things that are not allowed on the premise, including something like perhaps you're not able to serve alcohol on the premise. That's something that you want to know upfront, and some of those things are usually listed within the lease. There's also things that would be a trouble to other tenants that you might do within the property. We call it a nuisance. Those things are usually spelled out in a lease. It may include appearances, sounds, smell. So if you want to operate like a concert hall, for example, your commercial lease might consider that a nuisance, and it might say that this would put you in trouble with the landlord and the other tenants. In addition to all of this, you should keep in mind that your use of the premise should keep in mind any compliance with laws that the lease itself requires or just the law requires. So this would be a compliance with laws such as the Americans with Disabilities Act. And so something as like making sure that your business has an accessible restroom or has accessibility ramps. Those types of things are usually spelled out within the lease, but there are also commercial laws that you need to be aware of. As it relates to the use of premise, just a few things to keep in mind. You want to make sure that, again, the lease specifically spells out your intended use of that. Number two, if you require a permit for whatever you're going to use the facilities for, you might need to do that before you occupy the building, before you sign the lease. Consult with the local municipalities or your local city government to ensure that you are able to get the required permits to operate the type of business you want to occupy or you want to run at that particular location. Sometimes there's zoning laws that might prevent you from doing certain things at certain locations. Additionally, when it comes to not allowed activities, you want to consider future planning. So for example, if your commercial lease says that there should be no alcohol served on this facility, maybe your landlord just is of that belief, you may not want to sign that commercial lease if you're a restaurant, because even though you're not selling alcohol today, you might envision a time in the future, in a number of years, that you may want to serve alcohol and your lease prevents you from doing so. Lastly, when it comes to things that might cause trouble, one note here, make sure that you consult your lease before you make any changes. It may be something as simple as painting the color of your walls. Maybe your commercial lease says all the buildings are going to have the same color interior because we think that this is what our tenants want. And so if you're going to change the color of your wall, you need to consult your lease to make sure that it's not going to be a nuisance to your other tenants, to the other co-tenants within the same building. With that, let's talk about everyone's favorite subject, insurance. Now, insurance is built in to protect yourself, the landlord, and other third parties in the event that something goes wrong. There's a few areas that you should consider. Number one is asking the landlord to make sure that, and stipulated in the lease, that the landlord will get insurance for major structural things. These are like external fires, floods, etc. So if something happens to the building that you're renting, you want to, and you have millions of dollars, or you're doing a very profitable business, and now you're not able to use that space, you want to get your income back up and running as quickly as possible. So the commercial lease should spell out that the landlord is required to have insurance to fix major structural issues if something comes up. So that next point, or conversely on the other side of this, is rental insurance that you yourself may want to take hold of, so that if something happens internally in your unit, like if your property gets damaged or stolen, that you will be covered and you will be able to continue your business. Sometimes your landlord may require you to get renters insurance so that this can just guarantee that your business will continue to operate no matter what happens. The next category is business liability insurance. So like car insurance that you might have, every state requires you to have at least liability coverage. That means that if you hit someone else, then the insurance will be willing to pay out. And so this prevents you in case something happens, like a slip or fall, maybe a blow dryer explodes and it was unexpected and now you have a lawsuit. The business liability insurance will pay that third party in the event of something that happens. Similarly, workers' compensation will cover employees if they get hurt on the job. So if you have a restaurant, for example, it's usually required either in a commercial lease or in your local laws that you have workers' compensation that will pay your servers, your chefs, in case something happens within the restaurant. The next category is you are in the property, and of course, there is wear and tear, so things happen, and who's going to fix it? Well, the commercial lease usually spells out the things that the landlord is required to fix. These are usually things that are structural, things that are out of the tenant's control. It'd be like your ceiling falling down, or it might be mechanical, electrical, or plumbing issues. If you are savvy, you may want to negotiate within your lease. For example, if you are in Boston, we know snow happens all the time, and you're no expert in snow removal, so that's something that you might negotiate to have the landlord to explicitly cover within the commercial lease agreement. Conversely, on the other side of that, there are some things that you as a tenant may be responsible to repair yourself. So maybe it depends on the lease and what the language says, but maybe there's like a doorknob, right? And the landlord doesn't want to have to fix every doorknob that's not working. So some minor things might be on yourself as a tenant. So watch out for those things within the lease and have some provisions tucked away to fix those things yourself. Usually, sometimes this is excludes like reasonable wear and tear, something that the landlord should know needs to be repaired regularly, or things that are like damage because of natural disaster or fires that you did not cause. Those will still kind of fall into the landlord's repair category. Along that same lines, you're in the property, everything is going well, but now you want to make improvements, right? Or before you take a hold of the property, you want to make sure that this property is up to your standard. To do so, your commercial lease often will say that any improvements, alterations, additions will require the landlord's consent. One important thing to add here is maybe put it in a provision that says the landlord's consent cannot be unreasonably withheld, conditioned, or delayed, which means that the landlord can't have an arbitrary reason to tell you that you cannot make improvements to your property. But otherwise, most commercial leases will require the landlord's consent in order for you to make major alterations. This is especially important if you are making initial improvements because you want to spell those things out before you sign the commercial lease. For example, if you're a restaurant, there's a lot of things that may need to be done to a typical space, including something like installing an exhaust hood. And that requires drilling into either the roof or the floors above you to make sure that there's somewhere for the air to escape. That's a big renovation, and you want to agree with the landlord and the city. Remember my previous point about permitting. You want to agree with the landlord and the city before you sign the commercial lease to let everyone know and yourself know that you are permitted to make these initial improvements and who will actually be responsible for paying for it. Along the same line, something that's often not thought about is outside signage. Those are something that you would want to negotiate within the commercial lease itself to say, I have the right to put a sign on the marquee. This might even include something as you having the right to put an A-frame outside of your door. If these things are not negotiated and enumerated within the lease, you may not be able to do it. So something like that, you should get written consent in writing. One last topic here. When it comes to minor changes, you may think to yourself that I don't want to have to call the landlord every time I want to repaint my walls, which is already the same color, right? And so you may include within the lease agreement something that says tenant shall be permitted to make non-structural alterations to the premises following something like a 10 days written notice to the landlord. This, if you include this in your lease, will allow you to do minor things like painting the wall, maybe changing the toilet seat, right? Without having to consult the landlord. So that's a provision that we like to advise that you would put into your lease. Now, sometimes you might have different visions with the property in that you may want to share your space with someone else. That's what we call assignment or subleasing. An assignment is where you have someone to take over the remainder of your lease. So they're taking your right to the premise for the remainder of whatever term you agreed to with the landlord. That's an assignment. Now, most assignments require landlord's consent because the landlord wants to know who he's having a contract with. The usual exception for this is if you are selling your company outright to someone else, the entire thing is being sold. So for example, if you are a hairdresser and you're selling that hairdresser to someone else who's also going to operate this as a hairdresser, you don't need to, that person would want to know that they have a right to the space. And so that's usually and should be included negotiated for within the commercial lease agreement to say that if someone buys my business, the same business is going to continue, that they have the right to take over my space within this commercial property. A different arrangement to the same point is a sublet, where you're not giving your right away completely, but you're giving away a piece of it. It might be a small percentage of the entire property. So like, let's say you have contracted to own a warehouse or to use a warehouse, but maybe you don't need the entire thing. You might sublet a part of it, a room in an office, to someone else. Or it could be that you're letting them take the space for a short amount of time. So you still retain your right to use the property. However, you're giving a piece of that right to someone else. Like an assignment, subletting usually requires the consent of the landlord. And so you want to, if you have like subletting in mind, you want to make sure that you agree with the landlord on one or two things, that you have the right to assign or to sublet, or that you put a provision that the landlord's permission may not be unreasonably conditioned, withheld, or delayed, meaning that the landlord has to have an actual reason not to allow you to assign or sublease, and not just because they don't feel like it. One last key tip on this point You also want to negotiate for the right of first refusal. This relates to if the landlord themselves sells their right to their property, right? They sell their property to someone else, and now you no longer in contract with that landlord, so you don't really have a leg to stand on here. This will require that the landlord will come and talk to you first. So the landlord will come and give you the opportunity, your business the opportunity to buy the property before they're able to engage in selling it with another party. So this might be something, if you have a very long-term lease, it's important that you negotiate that the landlord will have to come to talk to you before they can sell their property. With that, there's some legal terms and protections we've got to talk through. This one is a big one. The word on the screen is an indemnification. An indemnification basically outlines who pays a third party if they're sued. If something happens and they're sued, it's just requiring that you would pay each other back for that kind of a situation. So let's say you are a tenant and the roof falls down. That's not your fault. That's in the landlord's territory of things to maintain. The roof falls down, but now there's a person in your restaurant or your hairdresser that was injured by this roof falling down, and they sue you and the landlord, right? It wasn't your fault. So an indemnification will require the landlord to pay you back for any money that you're on the line for to pay this third party. Similarly, the landlord may want you to sign an indemnification that says, if you are operating a restaurant and there's a slip and fall accident, the landlord is nowhere to be found. And so if a third party sues the restaurant, the business, and the landlord, because he owns the property, that you are required to pay the landlord for that person's harm or damages or whatever they're entitled to. And so one key point with an indemnification is to make the clause goes both ways. So landlord pays for issues coming from the landlord's negligence, and the tenant yourself will pay the landlord for things coming from your negligence. So everyone is responsible to pay for their own damages. That's the indemnification. Also, one last important note to this point is usually this is where we go back to the insurance. You can get an insurance policy that will protect you in the event that something happens, and now you have to indemnify the landlord. You should get an insurance policy that includes an indemnification to the landlord or vice versa, so that the insurance will not just pay you, but will pay the landlord as well. Next is how the landlord may try to limit their liability. If you are a landlord, this slide might be important to you because if you are operating a business and there is some kind of negligent event that happens and someone is hurt, those lawsuits, as you have seen on the billboards, can go up to $5, $10, $20 million. And the landlord's like, well, my property is not even worth that much. And so the landlord might try to limit the responsibility that they are on the hook for to whatever negligent or breach of contract. And usually the landlord will negotiate to have this to be capped at their value in the property. So they're not on the hook for a $20 million settlement in the event that someone gets hurt within your restaurant. The landlord should cover some kind of liability that will pay a minimal and requires you to cover some minimal policy that will pay out in the case that someone gets hurt. But you should also consider ways that you should get money back from the landlord if the shoes are on the other foot, right? So sometimes that might include withholding rent until the landlord pays you back for some conduct that breaches your lease. And so before you do that, however, we recommend that you consult with an attorney. We'll talk about that later on in a few slides. The next slide talks about the force majeure. French word, but it actually just means acts of God. These are things out of everyone's control, out of your control, out of the landlord's control, something that just happens as an act of nature, an act of God. There's a few things that fall under these categories, and it needs to be specifically stated within your commercial lease what events fall under the force majeure. Sometimes you want to contract, negotiate to have that force majeures will include natural disasters such as earthquake, floods, hurricane, wildfires. If you're down south or at some places, of course, you want to cover hurricanes. But if you're in Boston, what's one thing that you might want to include? A snowstorm or an extended snowstorm. Those things would fall under natural disasters. There's also government actions in the event of government shutdowns, emergency shutdowns, new laws, terrorism, regulations, things that will cause a disruption to your business that no one planned for, that the government does. Or sometimes, like we've seen with COVID, there's health emergencies that require that might impede your business in either from like a supply chain standpoint or something like that. So whether it be strikes or pandemics or some kind of government action, we want to figure out what to do when you are no longer able to operate the business. Usually, you can negotiate that if there is a force majeure, you can give some kind of notice to your landlord to say, hey, I'm not able to operate my business because there's a strike in California and I can't get my goods, right? And in the event that this is written in the contract that, hey, if there's a strike, I can't operate, the lease may allow you to either suspend payments for a period of time, or it may give you the opportunity to terminate the lease for a force majeure issue. But all of this needs to be spelled out in advance in the lease under the force majeure section. Next slide, and last for this section talks about a personal guarantee. So this is just something to look out for because there are some times where the landlord wants to ensure that they're going to be paid no matter what. So they may put in a personal guarantee, and this takes different forms. So keep in mind that it could either be a provision in the lease that requires you to put up your personal assets to pay the landlord for a whole gamut of things. Or it could be a separate document that the landlord asks you to sign. You should understand that document before you sign it. Or it could just be where the landlord asks you to sign the commercial lease in your name, like Darian talked about earlier, instead of the name of the business. Now you are on the hook for the terms within the lease and not your business entity. If your landlord demands a personal guarantee, again, watch out for it before you sign the lease. Try to limit that personal guarantee. Maybe say that, hey, I will only cover a number of months. So like, let's say I will limit this personal guarantee to just my first year, or if you include a burn-off clause to say that if I have on-time payments for maybe a year or two, then this personal guarantee goes away and my personal assets are no longer on the hook and only the business entity. So with that, that's the legal jargon out of the way for you. Now you might ask yourself, how do I negotiate for these terms? A lot of them are quite complicated. So we want to talk about a few negotiation tips to get you ready to face that landlord. Let's talk about a few tips. Number one, change your approach. We're looking at an interest-based approach to negotiations, which focuses on mutual benefit and has a very systematic step-by-step plan when you're negotiating in this way. The first thing you want to consider is your interest and your landlord's interest. I know that sometimes you might think your interests are obvious, but you need to consider what your interests are and how to articulate that to the landlord so that they understand and they were like, yeah, I get it, right? So you want to have a successful, profitable business. You want to have timely maintenance. These are some things that are important to you. You should write them down. But then also consider, what are your landlord's interests? They want to have on-time payment. They want their property to be used by you and then whoever comes after you. They want all the other tenants to feel safe and at home and are at peace in their property as well. So consider your landlord's interest and then frame your request within the interest of both parties, right? So for example, you might say something like, this outdoor signage I'm asking you for will increase foot traffic to my business, ensuring that you will get on-time payment. And so in this way, I'm framing my request with both of our interests in mind so that the landlord might see that we have some areas that we can work together on. Also, before you negotiate, consider your options. sometimes it's helpful to package a deal for your landlord. So going to the bundling issues together. An example of bundling would be, I might say I'll pay a higher rent amount for a shorter lease term. And so your landlord wants to be paid, and then they want you to be in the facility for a certain amount of time. And so you might couple those two interests of your landlord together to say, I know I can't sign a 13-month lease. I only want it for 8 months, but I'm willing to pay you more money in order to do that. So consider your options. And when you know your options, you're able to leverage them by bundling them together. Sometimes this is just an illustration. Some people might want the orange for the juice. Some people might want the orange for the peel. You may want very different things, but when you identify what your options are, what you have to work with, you can see how you might be able to increase the pie for everyone. On the next slide, a few other notes to keep in mind. Know your alternatives before signing the lease. It's helpful to be able to come to the landlord to say, I know you want to get paid for a fair amount for your property. The property on the next block over that's the same size as yours is being rented for X amount of money. So you're speaking to the landlord's interest with alternatives so that they know that you're comparing apples to apples. Similarly, you can take some templated provisions and say this lease should have this provision because I've seen it in other provisions, in other leases. Remember your options if there is a conflict. And so you should know before you sign your lease, if something goes wrong, can I take them to court? Can I sign the lease? Can I terminate and walk away? Know your alternatives. Consider your relationship as the next slide with the landlord as you're negotiating the lease. Two things. Understand that you're going to be working with this person for a long period of time. So that's thought number one. Thought number two, consider, do I want to have repeated interaction with him or her? Is this a person that I like? The negotiation process itself is a way to build a relationship and also point out red flags, and maybe that's not the right lease arrangement for you. With that in mind, communication is key. So use active listening and clear expressions as you talk to your landlord. And then the last slide just talks about the commitment. Make sure that you put everything in writing. Darren also said this, right? So you've heard this twice now. Put everything in writing. Use very specific terms that are clear and detailed. If a lease provision is complicated, ask it to be written in plain language. Make sure you do a final review of everything. And whatever you do, do not sign the lease without considering whether or not you can meet every obligation within that commercial lease, because your business, and sometimes you, will be on the hook for whatever you sign. With that, I believe we turn it back over to Darian that could ask a few checklist questions.
Yeah, thanks, Lawrence. So, like Lawrence just mentioned, this is a commitment. You're signing a commercial lease. It's a big commitment, and it's really important to thoroughly read through any contract before you sign it. That being said, it could be really hard to remember everything we've thrown at you here today when lease signing day comes. And with that in mind, we've prepared here for you a checklist of questions to ask yourself before you sign the lease, or, like right up to that moment you sign the lease. And I'm not going to read everything here on this slide. This is really just, a quick summary of everything we've discussed here. But as I mentioned before, BLDC will be posting these slides on their website. Feel free to take this checklist with you on lease signing day, or just have it right next to you when you're signing or about to sign, or even just reviewing for the first time that commercial lease. And I know Lawrence mentioned it. I mentioned it before. I'll say it for a third time. If you would agree to anything after you and your landlord sign the lease, make sure to put that in writing and amend your lease to reflect that change. Keeping a paper trail with you when it comes to these sorts of transactions is going to be your best friend. And before we get to the Q&A portion of tonight's presentation, we just have one final category we would like to discuss with you guys. And this is defaults and remedies of both landlords and tenants in Massachusetts. So, you've signed a commercial lease, you're running your successful business, and life is good. Unfortunately, that's maybe not always how it goes. What happens if your landlord fails to go through with the obligations of the lease? Or on the flip side, what if you failed to comply with the lease as the tenant? we'll discuss briefly some common ways that landlords might default or breach the lease and what rights you as the tenant might have in return. And then on the flip side, we'll be discussing common ways that you, the tenant, might default, or breach your lease and what the landlord can do in response. So, a couple common ways that the landlord might default on the lease or breach include failing to deliver the premises by the occupancy date. So, I know I touched on this briefly at the beginning, but again, it's October 1st. The lease says you're supposed to take over that property by October 1st. And for some reason, the landlord says it's not available. Be sure to go back and review your lease term provision because they may have defaulted or breached the lease at that time. Another one, failure to timely return the security deposit. And again, if that happens, first go back and review your security deposit provision of the commercial lease you've signed. Third, failure to repair, replace, or maintain common areas that aren't under yours as the tenant's control. So things like the sideways, driveways, parking lots. And again, if this happens, first go back and review some provisions of your lease, like the maintenance and common areas, and go from there. And finally, the breach of the covenant of quiet enjoyment. So this occurs when your landlord acts or maybe even fails to act in a way that interferes with your right to use and enjoy the rented property. Some examples of this might include something like your landlord entering the property without giving you that proper notice, failing to make some necessary repairs, failing to provide essential services like heat, or even failing to address noise complaints about other tenants. So some things that you as a tenant can do if the landlord defaults, we'll go through them here. But first and foremost, just to keep in mind, really exercise caution if considering any of these remedies you see here in front of you. Escalation should always be done wisely. So while it's not necessarily a remedy, your first step in some cases should be to provide notice, and more specifically, notice to cure. So should the landlord's default, for example, be a failure to correct or maintain that results in unsafe conditions, and this issue wasn't caused by you, you should first communicate directly with the landlord about the issue and give them an opportunity to fix the damage. And keep in mind, if you're communicating directly with the landlord for something like this, again, keep it in writing. And if they do not take that opportunity to fix it once you've notified them, seek further legal advice before fixing the damage yourself. The damage might be harder to fix than you expect, and you don't want to hurt yourself to try and fix it. One of the most common remedies available to tenants is a legal action for damages. So this is a claim for monetary damages, so money, and it's a tenant's primary legal claim against their landlord who has defaulted. These claims will typically include compensation for any money that you as the tenant have lost due to your landlord's default. And another remedy that may be possible, but big if there, is withholding rent. So in some instances and jurisdictions, this might be possible, but do not take this step without first seeking legal counsel. If you were to do this, and there is a risk that you could be in default, and then it could make your issue harder to fix. In general, your commercial lease is always going to be your first source to determine your legal rights and remedies. So like I mentioned before, if it's something to do with not maintaining common areas, go back and refer to your maintenance or your common areas provisions first and foremost. And then when you suspect your landlord has defaulted, first, I know it can be stressful when a situation like default arises, and you might just want to block out the landlord, but do not ignore them. Make sure, again, one, when you're communicating with them, everything is kept in writing in some sort of text that you can save, and then talk to someone else and consider your options. Then review your lease, as I mentioned before, and finally, make sure you're seeking that further legal counsel if you need it. And now I'm going to turn it back over to Lawrence, who's going to talk about the flip side, what happens if you as a tenant defaults and what your landlord might be able to do in response.
Thank you, Darian. So let's pick up where Darian left off. Now, on the flip side, there are a few things that are common defaults from the tenant's standpoint. Number one, payment issues. Not paying your rent on time would often be a violation of your lease. some leases or so you may be able to negotiate for a grace period, meaning that the landlord might have to give you up to 5 days, maybe 10 days. It should be listed in your lease to be able to pay. And outside of that, if you're paying late, then it would be a default. The next is abandoning your premises. Keep in mind that even if you're still paying rent, but you have abandoned the premise, this might be a breach of your lease and you could have to pay damages to the landlord. Lease violations, it may be something as simple as not fixing the door. It may be a violation of your lease. Or also, lastly, sometimes, well, bankruptcy may result in an automatic default under many leases, so keep that in mind as well. With that, there could be severe consequences if the landlord, if you breach your lease in one of those ways or in any other way that your lease might stipulate, including termination of the lease or require that you pay the landlord back for all of the months that you are not occupying the space. Sometimes the landlord may be able to lock you out of the premise, and also they may be able to seize your possessions and resell it at an auction. And so those are some things that the landlord may be able to do if you violate your lease in some material way. Now, there are some protections that you might want to negotiate for, that you should negotiate for, that would be helpful for you. Number one is a requirement that the landlord has to mitigate damages. By that, we mean that let's say you terminate your lease and you were supposed to pay through December and it is what now, May or April, that instead of being on the hook until December, you require that the landlord will go and try to find another tenant as soon as possible. So they have to like post it on the newspaper or website. And if they can get it covered in 2 months, then you only have to pay for 2 months and not until the end of your lease term. Sometimes with the mitigation of damages, you might be able to stipulate that says, I'm only going to pay 3 months of back pay because that should be a reasonable amount of time for you to find another tenant if I terminate my lease early. Another protection is a cure period that allows you a reasonable amount of time to be able to fix a default before the landlord can come in and seize your possessions or terminate your lease, right? So the lease should stipulate whatever that cure period is. Maybe it's 5 days. Make sure that this is stated in your lease, how long you have to fix something before the landlord can take action. We also know that litigation is expensive, and so there are alternatives. There are people that their function is to be a mediator or an arbitrator. So this is a lot cheaper than the typical court process that is lengthy and expensive. So you may want to put a dispute resolution clause within the lease that says that the landlord must first negotiate with you. Or if there's a dispute, that you're required to use arbitration, which is often cheaper than the regular litigation process. Lastly, you want to make sure that there's something in the lease or just you understand your rights when it comes to an eviction, that the landlord just can't put a lock on your door. He or she can't just come in and occupy your premise without going through the formal eviction process. So spell that out in your lease, or just make sure that you know the local laws to understand what your rights are when it comes to an eviction. To that point, and all of our points so far, these are sophisticated documents, so you may not want to do this yourself. This is not DEY territory. There's complex provisions, and you should seek professional review. Many times, leases are very expensive to enter into and to breach, and so we advise that you seek legal counsel and that you negotiate proactively and write everything down. So if there's an update to your lease, put it in writing so that you can have that documented. There are many resources available that you can tap into. One such resource, for example, is university legal clinics like the one at Harvard. We're at the Transactional Law Clinic that offers help with everything transactional oriented outside of conflict dispute or litigation. So there might be clinics that can help you. The Boston Bar Association usually provides referrals or to small businesses. As you know now, and as it was told earlier, BLDC, and they're dropping information in the chat as well, offers loans and other resources. and webinars like this one to give you information. The Greater Boston Legal Service also offers assistance. So there's resources online for you to go and check out. One example is the City of Somerville recently put out a handbook on commercial leases, and they have tips and tricks as well in there. So check out your local municipality and find out what resources are available to help you as you think about entering a commercial lease. Here at the Transactional Law Clinic, if you have a transactional issue outside of anything conflict resolution related, you can visit us at our website and complete an intake form. Provide us your business and your legal need. We'll do a review to see if you fit within the parameters of the people that we're able to help. And then if you do, we will schedule a consultant appointment to pair you with a student advocate and a supervisor, and we'll hear more about your issue. So if you think you might fall under that perimeter, feel free to apply at our website. With that, we are at the end of our formal presentation, and we're going to be here to answer questions. So don't leave before having your questions answered. I think we can turn it back over to Gisela at this point to maybe field the questions or let us know how you want us to proceed.